Title IX is supposed to protect female college students, but does it really? Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today, I'm going to ask for your indulgence because I've got some kind of bug going on. Yeah, I've got a head cold, I've got a chest cold, I've been coughing up pieces of lung all morning, so I would really appreciate it if you would just ignore the rather different tonal quality of my voice and allow me to suffer in silence. So, here we go. Title IX is a federal statute that is designed to even the playing field for women in college athletics. It's also designed to protect them from violence. If we're being honest, it was brought about by a general apathy toward claims by women that they were being abused in universities. And that was pretty much the case from about 1960 through 1980 when these statutes were passed. Now, Title IX is not perfect. It sometimes overreaches, and when it does, it most frequently treats men unfairly, denying them, in most instances, equal protection of the law and due process. For example, in some schools, men cannot confront or cross-examine their accusers. Evidence is presented that in any court in the country would be excluded because it's hearsay, and that's because the Title IX investigator goes and interviews the witnesses and comes back and repeats what those witnesses said in the Title IX hearing. But of course, those witnesses then are not available for cross-examination, and you have only the investigator's word that they did a competent and diligent investigation. Now, penalties for violating Title IX in college environments can be quite significant, including expulsion from the university, loss of scholarships, and loss of stipends. One of the complaints frequently voiced by men is that consent in sexual relationships is often revoked after the fact, and then they get charged unfairly with sexual assault. Women, on the other hand, tend to suggest that universities don't do enough to protect them. I have mixed feelings on the issue. I applied for a job as a Title IX coordinator at a university. The interviews, there were two of them, focused on how important it was to be the advocate for the person claiming they were abused, and that you really needed to lean in on that. In short, I felt like at that university, if the woman said it and the university just believed it, and no matter what the man said, that man was going to be disciplined. When I asked for what responsibility a woman had for overindulging, the university had a policy against alcohol abuse, I was met with silence. If a woman claimed to have been under the influence because she overindulged in violation of the university's policy, and she pursued a claim, I wanted to know if she was going to be held to account for overindulging. Now, the male was certainly at fault for taking advantage of the woman, and I don't minimize that, but she had some fault in that too. Well, when I asked that question, I was met with shocked looks. They were appalled by this question. Needless to say, I didn't get the job, and I've been eternally thankful, as I would probably have been fired on day two. That said, I believe all efforts should be taken to advise students before they start engaging in dating and other behavior that consent is a two-way street, and consent can't be relied on when the other party is inebriated. A person who takes advantage of a drunken partner should always be held accountable. But due process and the ability to confront and cross-examine witnesses should be preserved, as should access to lawyers. That's the way I feel. Now, the pendulum seems to swing both ways in these cases, and on any given day, at any given school, you can see abuses going both ways. And that brings us to the case of Delores Lozano. She sued Baylor University for violating Title IX for injuries she says she received at the hands of one of its football players. Lozano claims 3 physical assaults by her ex-boyfriend, former Baylor football player Devin Chafin. She claims the university's campus culture created a heightened risk for her assault, and its employees failed to properly handle her reports. Lozano told the jury that back on March 6, 2014, Chafin slapped her, struck her, shoved her in his closet, kicked her in the stomach, and then dragged her back into his room and choked her into unconsciousness. She showed photos of bruises on her arms and both sides. Apparently, there were no images of the bruises on her neck that should have been there if she'd really been choked into unconsciousness. Now, Delores made the claim, and it was certainly backed up by the report by the law firm, that Baylor had a tendency and a propensity to look the other way when this involved football players. And I think the Pepper Hamilton report sort of bears that out. But as bad as some of the things that were reported in the Pepper Hamilton report were, they were not directly relevant in Lozano's case because of the way the university handled her case. In closing argument, Lozano's attorney said the Baylor football team's success on the field meant players got away with bad conduct. He used a report done by the law firm to show that the firing of the football coach established a pattern of indifference. In other words, they were being indifferent to these claims of abuse. He said, "We know that in the years that preceded the assault on Delores, football players were taking advantage of women all the time and again, and nobody was doing anything about it, and that's deliberate indifference." But Lozano's story was vastly different from her boyfriend's story. In his video testimony, Chafin acknowledged that Lozano did come to his apartment on March 6, 2014. He said the conversation began with tearful empathy. "Then she turned on me," he said, "and told me that I should have stood up to her father and mother. She became very angry, and I asked her to leave. She started slapping me and scratching me, and I went to leave, and she blocked my door. I grabbed her hands to stop her from hitting me." When it was her turn to address the jury, Baylor's attorney downplayed Lozano's attorney's rhetoric and noted that under the law, his claims are not evidence. Now, the Baylor attorney had a really difficult job. She had to humanize the person who supposedly was the aggressor here and do so without throwing the supposed victim under the bus. So she started with a concession to Lozano, saying, "We're not engaging in victim blaming when we come in here and defend these claims that Ms. Lozano brought." And she's right. You don't blame the victim, but you do point out if she's exaggerating. She said there was a real factual dispute about what happened between Lozano and Chafin on 3 dates, and both testimonies must be weighed. That's what the university did when it handled her complaint. It took account of both her testimony and that of Chafin. She argued that Chafin's description of events was more in line with the evidence, and she questioned how Lozano, who was too embarrassed to go to tumbling practice because of her bruises, was still willing to go to South Padre Island and wear a swimsuit.
Hey folks, please excuse the interruption, but let me ask you if you haven't already, please subscribe. And if you would, hit that like button and maybe even leave a comment. That tells YouTube that this is a valuable video and they'll refer it to more people. It helps me out a lot and I appreciate it. Thank you.
At one point, there was a medical examination. Baylor's lawyer noted that nurse practitioner who saw her on April 9, 2014, about a month after her initial March 16th incident, told her that her boyfriend had grabbed her and shoved her and said if she had told me that he'd done more than that, I would have made a note of it. Well, Baylor's attorney told the jury that numerous Baylor staff encouraged Lozano to seek counseling and go to the police. She showed the jury notes from a counselor who saw Lozano at the counseling center. She showed the jury a police report from the Waco police and how they had offered her a protective order, and she refused. One thing that often happens is that prior lawsuits become relevant when claims are made there that work against the claims made in the instant lawsuit. Baylor's lawyer reminded the jury of Lozano's prior lawsuit against Houston Metro over a 2018 bus sideswiping her car, in which she sought damages for mental anguish, claiming she had no mental anguish before the sideswipe. This was a deft characterization of Lozano as an aggressive litigant and serial plaintiff who said whatever was necessary to get money. Baylor argued that since Lozano took part in student celebrations and graduation the month after the last incident, well, her GPA didn't suffer, so she didn't endure any of the effects of discrimination. In short, the defense lawyer here is doing what defense lawyers always do. They go after the inconsistencies in a person's claim, and that's what she was doing. Now, do I believe that Lozano was a serial plaintiff and just an aggressive litigant here and looking for a huge pile of money? I really doubt that because she has endured since 2016 and it's 2023. It's 7 years after she filed this lawsuit, 9 years after the initial assaults in the case, and she has stuck it out. And so, in my view, she probably did suffer some effects from what happened, but I don't know, and I think the jury will be able to determine who's telling the truth. I wasn't there. Based on media reports, which is what I put all of this together from, I'm not sure that she's going to be able to recover. Baylor's lawyer said that whatever happened between Lozano and Chafin, it was the result of a unique situation between the two of them. She said Baylor didn't cause the conflict and couldn't have prevented it. And I think that's right. In other words, it was domestic violence and not a Title IX case. She said, I told you at the beginning of this case that Baylor would accept responsibility for the filings and the findings of fact. That was the document that was put together by the Pepper Hamilton law firm about the problems in the Baylor's sports program. But I also told you that this case was not like those cases in the findings. Baylor did not look the other way. Baylor looked directly at Ms. Lozano and offered her support. And as noted, Lozano didn't accept the help and the support offered. So she can't make those choices and then turn around and try to hold Baylor responsible. In classic defense counsel mode, she told the jury not to get distracted from the evidence in the case. In other words, question the motives, question the inferences that she's drawing. It's Ms. Lozano who wanted you to look the other way, at the findings, at the other football incidents, at everything but her own case. Because in this case, Baylor got it right. They looked directly at her and offered her help. Now, in addition to everything else, Lozano's claims face another hurdle. There is a 2-year statute of limitations built into Title IX. What that means is that within 2 years after you know you've been injured, you have to bring a lawsuit. She was injured in March and April of 2014, but she didn't file her lawsuit until October of 2016. Well, that puts her well outside the 2-year time frame. And as Baylor's lawyer said, she certainly knew she was injured, and she certainly knew the causal connection that she suggested between Baylor and what happened. So why didn't she act? And Lozano's lawyer said, well, this is a Hail Mary because, it doesn't apply here because she wasn't aware her experience was part of a widespread problem until the publication of the findings of fact in May of 2016. That argument's going nowhere because what triggers the statute of limitations is your knowledge that you've been injured. Whether other people have been injured or not is not relevant. What is relevant is when were you injured? When did you know you suffered an injury? And what did you do about it? And unfortunately for Ms. Lozano, she did not get her case filed in time. She knew well before the report was issued that there was something going on because there's a great deal of media coverage about this. That's why Pepper Hamilton was effectively hired. So where does this all wind up? My guess is that if the jury finds liability, Baylor will appeal and they'll prevail on the appeal because of the statute of limitations issue. That's a winner. But given the evidence in this case and the differences between the testimony, it's just as likely that a jury could go the other way. Either way, I will report back on this case and keep you updated on it. If you have the opportunity today, take a moment, do something nice for someone. Doesn't have to be a big something. It can be a small something. Maybe just open the door for someone. Do that. Make the world a better place. Well, that's what I have for you today. Be thoughtful, be kind, and if you don't mind, be back here tomorrow. We'll talk about something else interesting. Have a terrific day, folks.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.